All right, welcome everyone. Let me first thank Terry Skolnick, who co-directs the University of Ottawa Public Law Centre, which is hosting this event in conjunction with Tribunal Watch Ontario. Terry?
Thank you very much, Raj. Welcome everyone. Bonjour et bienvenue à tous et à toutes. Thank you all for coming today. I'm going to begin with a brief land acknowledgement, and then I'm going to pass it over to Raj, who's going to introduce the panelists for today. We pay respect to the Algonquin people, who are the traditional guardians of this land. We acknowledge their long-standing relationship with this territory, which remains unceded. We pay respect to all Indigenous people in this region from all nations across Canada who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. So today's moderator is Raj Anand, who's a partner at Weirfolds. He is a former bencher at the Law Society of Ontario. And Mr. Anand is the chair of the Board of Governors of the Law Commission of Ontario. He's also a former chief commissioner of the Ontario Human Rights Commission. And Mr. Anand practices in the areas of human rights, constitutional administrative law, labor relations, civil litigation, professional negligence, and discipline. And so I'm going to pass it over to Raj. Thank you very much, and welcome everyone.
Thank you very much, Terry. C'est avec grand plaisir que je vous présente nos quatre excellents intervenants. I'm delighted to introduce our four panelists. Let me confirm at the outset that none is a member of Tribunal Watch, and their participation does not necessarily mean endorsement of positions that Tribunal Watch has taken. You can find out much more about Tribunal Watch at its spanking new website at tribunalwatch.ca. Premièrement, la professeure Anne Lévesque, qui commencera par parler de l'importance d'un système et un code ontarien des droits de la personne exécutoire. Professor Anne Lévesque will begin by talking about the importance of a functioning human rights system and an enforceable human rights code. Elle abordera certaines des conséquences juridiques et sociales lorsque les tribunaux cessent de fonctionner correctement. Anne has practiced, advocated for, and/or taught human rights, French language rights, constitutional law, in many settings, including the Canadian Disability Rights Council, the National Association of Women in the Law, the Child Caring Society case before the Canadian Human Rights Tribunal and the courts. After she obtained her master's in international human rights law, the University of Ottawa was fortunate to capture her to join the common law faculty a few years ago. Nous avons trois autres panélistes qui parleront de leurs propres observations sur ce qui se passe au Tribunal ontarien des droits de la personne, y compris des histoires pour illustrer les faits sur ses clients. Our three other panelists will speak about their own observations about what is happening at the HRTO, including stories to illustrate the impact on their clients. Two practice principally on the applicant side, one on the respondent side. And I do work for both applicants and respondents. Wade Poziomka is a partner with Ross and McBride in Hamilton. His human rights work has been local, international, national, academic, and he has also been heavily involved in advocacy and in the community. He also practices union-side labor and employment law. Antonella Chedia has over 25 years of experience at the provincial and municipal levels in law and in the private sector. In the area of human rights, she speaks and writes frequently, teaches in undergraduate and graduate courses, and advises and represents the City of Toronto, the Toronto Police Services Board, and the Chief of Police. Richa Sandil is a staff lawyer at Don Valley Community Services, where her practice focuses primarily on advising and representing marginalized and low-income workers on all aspects of employment law, including test case litigation, workplace harassment, discrimination, and wrongful dismissal. She has served in many capacities with the Ontario Bar Association and with the South Asian Bar Association. And before going on, I mentioned Tribunal Watch Ontario, and I want to give my thanks at the outset to Brian Cook and Kathy Laird, who have done the bulk of the organizing of this conference with Terry, of course, from the University of Ottawa. So I want to say a few words about Tribunal Watch Ontario's statement of concern, which it has been working on about the HRTO in concert with this webinar. And so after saying a few words about that, I will go to our panelists. I'm going to spend a few minutes on some of the statistics and trends in the statement of concern that is being drafted. Again, as I said before in a different context, the statement is from Tribunal Watch and is not intended to reflect the views of the webinar panelists. Nevertheless, any comments, obviously from our panelists and from the hundreds of participants that we have online, are most welcome. So I want to say something about three quick points. Firstly, in terms of the Human Rights Tribunal of Ontario, the changes in terms of complement and expertise. In 2018, there were 21 full-time vice chairs, 34 part-time members. By 2020, it was down to 6 full-time vice chairs, 4 full-time members, 12 part-time members. And now there are 6 full-time vice chairs and 15 full-time and 19 part-time members. But many adjudicators, including some of the full-time members, have cross appointments or other positions. In many cases, they do not appear to have any adjudicative or mediation, to do any adjudicative or mediation work for the HRTO, because their time is needed by their home tribunals, which also have a large backlog of cases. Statutory compliance is in question because the code itself and ATAGA, the Administrative Tribunals Act, make subject matter and ADR expertise criteria of appointment. Second, in terms of the numbers of merits hearings and merits decisions, the HRTO has held very few full evidentiary hearings in the past couple of years. In 2021, the tribunal issued 36 final decisions that determined, based on the evidence, whether discrimination contrary to the Human Rights Code had occurred. In 2017, there were 167 merits decisions. Significantly, all 36 of these final decisions released were overwhelmingly written by the experienced adjudicators who are now no longer appointed to the tribunal. In many cases, the decisions were completed by these adjudicators after their terms had expired. This means that very few of the newly appointed adjudicators have conducted a full evidentiary hearing or written a decision about whether or not discrimination has been proven. Indeed, 80% of the final merits decisions released in 2021 related to applications filed between 2014 and 2018. I was told recently that when a mediation concluded without settlement, that the hearing would start 18 to 24 months from now. Third point, change in understanding of jurisdiction. Again, in my view, an issue of statutory compliance. Subsection 43 sub 2 of the Human Rights Code states that the tribunal may not dispose of a case that is within its jurisdiction without providing the opportunity for a hearing. A significant number of applications have been dismissed without a hearing on the grounds that the application is not within the tribunal's jurisdiction. These decisions typically indicate that an applicant has filed an application alleging discrimination by the respondent, but that in the tribunal's opinion, the applicant has not established a sufficient link between the alleged treatment and a prohibited ground of discrimination. Such a determination evidently requires an assessment of the merits of the application, which should not be confused with a determination about jurisdiction. Let's go then to our panel. I should mention that for questions, participants other than panelists can use the Q&A function in Zoom, and we'll attempt to field those questions with the assistance of Brian and Kathy, who are with us. And so let me move to Anne.
Thank you so much for your introduction, Raj, and for the public interest, the Public Law Center for organizing this panel. So my role in in this panel was to talk about the importance of human rights regimes. So I'll be speaking specifically about the history of the Ontario Human Rights Code, the purpose of human rights legislation in general, and giving some examples of why efficient, effective human rights remedies, quick access is important in a democracy. With a focus on the role of Ontario Human Rights Tribunal in particular. So throughout Canada, human rights laws emerged after World War II, when everyone recognized the importance of the law and the role of the law at addressing discrimination. We recall the decision Christie versus York, where we learned that private law did nothing to address discrimination. And in the backdrop of World War II, there was a consensus that the law could play a role. Canada signed the Universal Declaration of Human Rights, and we saw statutory human rights laws, anti-discrimination laws emerge throughout the country. And Ontario, and this is very important to highlight, Ontario has always been the leader in terms of anti-discrimination legislation. In 1944, the first law banning the public display of discrimination in signage was passed. In 1951, the banning of race and religion-based discrimination in the context of employment, and then in pay for women was passed in 51. A law discriminating, prohibiting discrimination in public services in 1954. And finally, in 1962 is when we saw all of these kind of piecemeal legislations that address different forms of discrimination in different contexts. We saw the Human Rights Code. So that was the first human rights legislation, comprehensive human rights legislation in Canada. There's been various modifications, but one I'd like to speak to in particular was in the mid-2000s, where there were major changes done to the system, where Ontario implemented a direct access system. So that would rest upon the three pillars. So the commission would still play its role in promoting human rights, in encouraging compliance, in playing a role in public education with regards to discrimination and human rights obligations. And then there would be the center that would support complainants in light of the imbalance of power that often exists between complainants and respondents. And then the tribunal. And I recall I had just been called to the bar, and it was such a promising time for human rights lawyers and respondents alike. I think respondents were also very frustrated with the human rights system that was slow and inefficient at the time. And the tribunal at the time, what I recall is it really was an all-star team of adjudicators. The people who were appointed had experience on the ground working with equality-seeking communities. They knew what discrimination looked like. They were experienced adjudicators. And what we had was a really fast, accessible system that worked really, really well. And emerged a really rich body of jurisprudence. So when considering how the Human Rights Tribunal of Ontario functions, I think it's really important to recognize the way that the tribunal plays a leading role for all human rights tribunals across the country. When you're doing human rights in federally or in any other jurisdiction, the source of case law is always the Ontario Human Rights Tribunal. I appear before the Canadian Human Rights Tribunal more frequently, and the procedural questions that emerge, we always turn to the Ontario Human Rights law for the case law on the procedural issues, because it's seen so many cases, and the adjudicators were so experienced. So we'll hear a bit more from our panelists about what's going on now on the ground. But before we turn to that, I'd like to speak to just the importance. It must be recalled that it's not just a tribunal about resolving private disputes. It's got a public dimension to it. And when someone files a complaint, I always describe it to my students as a public service, because human rights legislation recognizes discrimination as a public wrong. And the primary method of enforcing that and in achieving that public objective is complaints. So every time a complaint is filed by a member of an equality seeking group, that person is acting for free. They're doing a public service by implementing a legislative objective that we've all agreed upon is a valuable public objective of eradicating discrimination. And these people take on big respondents at a huge personal cost, and they deserve an efficient hearing. Some of the remedies that have been achieved have benefited all of Canadians. I think of a Hugh versus Ontario, a case before the Canadian Human Rights Tribunal, a decision rendered in 2010, where someone who faced mobility barriers when voting filed a human rights complaint about the lack of accessibility at the polling station, and a 2-page document of the human rights complaint helped achieve broad systemic remedies in all of the facets in which polling stations are chosen by Election Canada, how the people are trained, what the complaint mechanism is for when there are problems with accessibility. One piece of paper can achieve systemic change that will benefit all members of equality-seeking groups. Other stakes that have been adjudicated, issues that have been adjudicated, I'm going to point to the Caring Society, of course, really historical case that was adjudicated and before the Canadian Human Rights Tribunal, and really dealing with life or death situations, for example, situations involving teen suicide pacts, children who did not have access to mental health services that were available off reserve, and the tribunal rendered decisions to make sure that Canada was complying, very specific decisions. And had we not had an efficient tribunal with experienced adjudicators with experience in human rights, none of these victories would have been possible. Now, specifically from a legal perspective, just about the role of Human Rights Tribunal, when Canada goes internationally, it often points to human rights tribunals and its human rights legislation in general as they're implementing statutes for Canada's international human rights obligations, whether it be towards children, eradicating racial discrimination, for example. These are actually required under international human rights law, and as well as Section 15 of the Charter. And during the pandemic, finally, my last point is there's a host of legal issues that are emerging where employers and victims, service providers do not have any legal guidance on how to manage really novel situations that are coming up, because we don't have a body of jurisprudence coming out from the Human Rights Tribunal. I'm thinking of the requirement to impose masks, for example, in certain employment settings where employees might be vulnerable due to a disability, or employees might have children who are unvaccinated or being providing care for elderly family members. I think myself, I'm a woman in a workplace. My family obligations have increased during the pandemic. What is my employer's obligations to accommodate me? It would be very helpful to have case law emerging from the tribunal on these very important issues that employers, service providers, employees, customers are trying to navigate. But the tribunal has been silent, right? We haven't been getting these decisions. We saw this morning the BC Human Rights Commission issued a statement on masking and encouraged service providers and employers to consider a mandatory masking policies in certain settings where there were vulnerable individuals. It would be very helpful to have legal guidance from the tribunal on these issues. And finally, one thing that must be considered while you hear our other speakers is the context of these attacks on the tribunal and the fact that the tribunal is paralyzed, and at the same time, the attack on legal aid and our clinics in particular. Our clinics, community clinics, are really struggling to recover from the cuts in 2019. These are, the Human Rights Tribunal has been described as a refuge for the disadvantaged, and the clinics are the pillars of access to justice for people living in poverty in Ontario. So we have really a perfect storm of access to justice on the issue of discrimination and human rights, where people are just being deprived of the means to assert their most fundamental rights. So those are my remarks. I'm looking forward to hearing from the other panelists.
Actually, let me just ask you one thing on the issue of access to justice before we move on, and that is French language services and what impact that you seen in terms of as a result of of access to justice before the tribunal.
So that's huge. I think the Francophones who live in poverty or who face intersectional barriers are really stuck between a rock and a hard place. On one hand, we have the Ontario Human Rights Commission that generally ignores issues relating to Francophones. There's been recently, for example, a report on the right to learn that Francophone school boards were not consulted. There's a lack of Francophone people on the advisory group. There's no Francophone members. And then on the other hand, we have the tribunal that is not listening, doesn't have any members, like to my knowledge, that can hear complaints or applications in French. So there's actually been a mandamus filed to force the appointment of Francophone members, but Francophones who face intersectional barriers are really being ignored. In particular, I think I actually don't think that the tribunal has the capacity to hear currently any applications in French. And the language commissioner is not applying an intersectional lens and has been completely silent on the issue of access to justice before administrative tribunals for the most disadvantaged. So I think this is a huge concern that must be talked about by members of the language community in particular. I'm hoping to shed some light on it, but this is my understanding is there's currently a mandamus before the court that says that there's actually no members that are equipped right now to hear hearings in French at all.
Thank you very much. I wasn't aware of that, and thank you so much for your introduction and setting the context for our three remaining speakers. So let me turn right away to Wade.
Raj, thank you for the kind introduction, and thank you, Anne, for your thoughtful comments, and thank you for the invitation to speak this morning on a very important issue. So many of us who practice in the area of human rights are very aware of the problems facing the Human Rights Tribunal currently. Recent information suggests that there's a backlog in excess of 8,000 active cases. Files are taking anywhere from 2 to 7 years to reach a final decision. Not all adjudicators are doing hearings. My understanding is that there's only a handful, which to me indicates that this backlog is only going to worsen. Hearings are being done virtually, which has some pros, but it also presents some human rights issues for applicants based on code protected grounds and perhaps also socioeconomic status. And so, to the extent that power imbalance between a representative respondent and a self-represented applicant who may not have the means to participate fully in a hearing or to participate as fluently in the hearing will only heighten. Settlement is likely more difficult to achieve because of the virtual and telephone mediations that are happening. So all of this to say, the tribunal is not in a great state currently, and there's no real indication that things are going to improve. And all of these problems have a significant impact on both applicants and respondents. Now, there's many anecdotal stories I could share. I'm just going to touch on a couple of points. Clients who've experienced sexual assault or sexual harassment looking to move on in the healing process, for example, they're sitting there for 2 to 3 years, sometimes longer, before they get to a hearing. And then they have to go through the facts all over again. And of course, experience the trauma that comes with that. Situations where discrimination is ongoing, where the relationship between an applicant and a respondent is still happening. A failure to accommodate situation, for example, where the employee's off work, experiencing a wage loss. Obviously, at an impasse in a duty to accommodate case, if that applicant's off work and it takes 2 to 7 years to get to a hearing, the hearing's probably going to be moot by the time they get there. When the change in adjudicators occurred at the Human Rights Tribunal, I had several matters that were in the midst of a hearing or a preliminary hearing, and many of those had to start all over again. So the cost and the additional stress, now applicants having to relive the stress of going over the facts twice, and of course 2, 3, sometimes more days of wasted hearing time. And then finally, the impact, and another problem that I'm seeing is consistency in case law. So many of you would have read the Empower Simcoe case that was released, and a short while after that case was released, we saw a 3-member panel of the Human Rights Tribunal issue a decision that essentially said they disagreed with the approach taken by the adjudicator in that role. And what really struck me is when I was reading that decision, a 3-member panel saying respectfully we disagree, it was almost sitting in an appellate function, or it appeared to. And from my perspective, this makes it really tough for practitioners on either side of the fence, whether you're applicant or respondent, to understand the state of human rights law and to properly advise our clients. The code aims to create a climate of understanding and mutual respect for the dignity and worth of each person. That's right in the preamble of the code. But if that person has to wait 2 to 7 years for a determination of discrimination, that's maybe 1/10 or 11th of their lifespan. Can anyone really say that the code's aims are being met? So we know we have a problem that has a substantial impact on both applicants and respondents. But what's really concerning to me, and what I want to talk a little bit more about today, is where the tribunal will go from here to address that growing backlog, and whether that approach will be principled or unprincipled. Now, let me be clear, I'm not suggesting that any member of the Human Rights Tribunal is unprincipled. I have been having some great experiences at the tribunal recently as well. I'm currently in a 2-week lengthy hearing with a newly appointed adjudicator. Very efficient and fair process, has demonstrated a very thorough understanding of human rights. So I'm not here to attack or denigrate any individual adjudicators, but I'm more concerned with the procedures and processes that the tribunal is going to follow as a whole to address the backlog. So let's assume for a moment that all of us here today, the speakers and the participants, are tasked with addressing the problems currently plaguing the tribunal. Here are some things that we could do to get rid of the backlog. I don't know how many of you are familiar with C.S. Lewis's book, The Screwtape Letters. It's about a demon named Screwtape who writes letters to his nephew who's named Wormwood. And he's an incompetent tempter, and he's being trained. And it talks about how to cause humans to fall into temptation and generally do evil deeds, but it's written from the perspective of the bad guy. So I feel like I'm taking a Screwtape Letters approach to the Human Rights Tribunal right now to address this backlog. So if I were running the tribunal and I wanted to clear up the backlog, and I didn't care about the purpose of the code or justice, here's what I would do. And I'm not suggesting that this is the case, but this is what I would do in that scenario. The first thing I would do is find that HORIX applies in Ontario, and I'd toss out a whole significant number of matters before the tribunal where applicants work in unionized workplaces. For those of you who aren't familiar with HORIX, it was a Supreme Court of Canada decision issued a few months ago on October 22nd, 2021. And it found that based on the specific statutory regime in Manitoba, which is different from Ontario, individuals with human rights issues must pursue the matter through the grievance procedure, which has exclusive jurisdiction, which also means that the Manitoba Commission does not then have concurrent jurisdiction. So if it's found to apply in Ontario, most employees in unionized workplaces would no longer have the choice of pursuing an application at the tribunal or filing a grievance. They'd be limited to the grievance. Now, for those of you who don't know this yet, the tribunal has ordered a 2-day preliminary hearing on 2 human rights cases to be heard by a 3-member panel of the tribunal that will take place in May. I have a case that was in the midst of a hearing. It was about 2 weeks in, and we adjourned a couple of days in February on the basis of Horrocks. And it's for this reason that I anticipate we'll have a decision from that 3-member panel of the tribunal probably in June of this year, ruling on whether Horrocks applies in Ontario or not. And then, of course, whichever way they rule, likely we'll see a judicial review, and it will move on up in the process. Now, many of you already know my view on Horrocks, that it doesn't apply in Ontario. David Baker, Paul Champ, and I wrote a quick blog post shortly after that decision was released. But I digress back, and if I were the tribunal and I wanted to address the backlog and I didn't care about the principled approach, I would find that it applies and I would eliminate a significant number of cases. The next thing that I might do is figure out a way to dismiss applications without expending significant tribunal resources, like issuing NOIDs or notices of intent to dismiss on the basis of jurisdiction, because the applicant has not established a sufficient link between the alleged treatment experienced and the prohibited ground of discrimination. And by treating it as a jurisdictional issue, we can avoid section 43(2) of the code, which prevents the tribunal from dismissing an application within its jurisdiction without affording the parties the opportunity to make oral submissions. So if you skew the jurisdictional issue and you treat something as a jurisdictional issue, you can toss it right off the bat. You don't have to take tribunal adjudicator resources and hold a summary hearing and then issue a decision on it. Now, what I'm seeing in my practice, especially from applicants who are self-represented when they file their application, are NOIDs being issued in circumstantial evidence cases where some of them where discrimination is not only possible, but it's probable. Now, most of the cases before the Human Rights Tribunal are and always have been circumstantial evidence cases. These require a summary hearing to determine whether there's a reasonable prospect of success, not mischaracterization as a jurisdictional issue, so we can dismiss it without expending time on it. I've seen NOIDs issued on very clear cases of alleged discrimination, but the link is abundantly clear. And at this point, I can't make sense of it. And my worry is that the tribunal will use this process to clear the backlog. And I think if that's the case, we'll see unfairness, especially towards self-represented applicants at the tribunal. Now, my experience with this is anecdotal. I've heard from other practitioners on the applicant side that they're experiencing something similar. And I hope I'm wrong, and maybe it's a learning curve of adjudicators and not an intentional system in place to clear that backlog. Finally, the next thing that I might do if I were an adjudicator trying to clear that backlog is hit the self-destruct button and adopt the decision of the Saskatchewan Court of Appeal in Abrametz versus the Law Society of Saskatchewan. And I just want to take a couple of minutes and just briefly summarize that case for those of you who aren't familiar with it. It's been heard by the Supreme Court of Canada, and I believe we're waiting for a decision on it still. So in 2012, the Law Society of Saskatchewan initiated an audit investigation into a lawyer, and it looked at several allegations, one of those allegations being tax evasion. In 2015, that Law Society proceeded on 7 charges against the lawyer, but tax evasion wasn't one of them. In 2018, so now 6 years after initiating the audit investigation, they found him guilty on 4 charges related to financial misconduct. Before the penalty hearing, the lawyer applied to stay the proceeding due to delay, arguing a breach of natural justice and procedural fairness resulting in an abusive process. The hearing committee denied the stay application and found that the 66-month period from the start of the investigation to the finding of guilt was appropriate given the complexity of the case, size of the investigation, and the delay attributable to the lawyer himself. In January of 2019, the hearing committee ordered disbarment. The lawyer appealed to the Saskatchewan Court of Appeal, and that court, applying a correctness standard to the issue of delay, reviewed the principles that were articulated in Blanco. And for those of you who are unfamiliar with Blanco, which is probably the minority of you, but for those of you unfamiliar, Blanco basically said there's a narrow range of circumstances where delay could constitute an abusive process. It would have to be so inordinate as to be clearly unacceptable. A person must suffer significant prejudice, and the court must be satisfied that the harm to the public interest if the proceeding were to go ahead would be greater than the harm to the public interest if the proceeding was halted. And the court concluded in that case by saying few lengthy delays will meet this threshold. And that's what we've seen in subsequent jurisprudence following Blanco. Now back to the Abrametz case. After reviewing Blanco, the court found that the delay from the start of the investigation of the Law Society to the beginning of the hearing, being 32.5 months, constituted undue delay. The court weighed the fact that there were serious charges against the lawyer on the one hand, and it's the Law Society's mandate to protect the public interest, and compared it with the fact that the lawyer had not misappropriated funds, the tax evasion possibility wasn't at issue in that hearing, no clients had complained to the Law Society, and the lawyer is a longstanding member with no prior disciplinary history. The court stayed the proceedings, set the penalty aside, but maintained the misconduct findings. Now, what's really interesting about this case is it relied heavily on jurisprudence out of the criminal context around delay in 11B of the Charter. And they stated in that decision, why should less be required of administrative decision makers in courts? The court was aware in this case that it was treading into new waters, and it acknowledged that the outcome that the lawyer had sought was not an easy fit with the subsequent interpretation of Blanco by the courts. In my view, it lessened the threshold for dismissal of administrative matters for delay. And I've seen on at least 3 matters that I have before the Human Rights Tribunal where respondent counsel has raised this argument and asked the tribunal to dismiss based on the tribunal's institutional delay. Now, this matters before the Supreme Court of Canada, like I said, and I think, speaking to my colleagues on the respondent side, some of them are banking on a decision coming out from the Supreme Court that will lower the threshold and open the door to this possibility. But it's very possible that the tribunal could adopt this reasoning and lower the threshold, dismiss applications, and then of course there'll be reputational consequences that would flow from that for the tribunal, but the pandemic in part can relieve from that. So that's something that worries me that we might see happen in the future as well. It should be noted that other courts like the British Columbia Court of Appeal recently declined to incorporate Jordan principles and criminal concepts into the issue of delay. But we do know that the Supreme Court is reconsidering Blanco. So to conclude, my thoughts are that the tribunal's in trouble with the current backlog. My worry is that the temptation will be a quick fix, finding that Horrocks applies in Ontario and the inappropriate twisting of jurisdiction. I think that will be tempting to eliminate some of that backlog. My hope, however, is that we'll see a principled way forward that involves the hiring of additional experienced adjudicators, hard work and thoughtful analysis from the members of the tribunal as they slowly reduce the backlog in a principled manner that instills confidence in the administrative justice system. Thank you.
Thanks very much, Wade. Let me just follow up for a moment about the Blanco-Abrametz delay issue. And I raise it because this has arisen in the Ontario Law Society as well. I know that because I wrote a decision that got reversed by the Court of Appeal for the Law Society Tribunal on reducing a penalty as a result of inordinate delay. But I raise it only to say that you don't need the Jordan principles and so on. I mean, under Blanco, obviously procedural fairness and the integrity of the administrative justice system is probably sufficient in terms of, in an extreme case, in terms of that. So, I mean, do you see this? You mentioned that there are a few cases in which you're facing this argument on the respondent side. Do you see this as an increasing trend at the HRTO in terms of raising institutional delay?
Yeah, I do. I mean, because I've only seen it in the past couple of years. I haven't really seen institutional delay argued, with the exception of my colleagues at Ross McBride and I argued the Fair versus Hamilton School Board case, and there was some institutional delay raised in that case. But other than that, I haven't really seen it except for the past couple of years. And so, yeah, I think that the reason why counsel will rely on the criminal side of this when they're trying to make that argument is because the Saskatchewan Court of Appeal opened the door to it. And of course, we know the threshold is much lower in the criminal context because liberty interests are at stake. You're against the state, for example. But I take your point, Raj. I agree that it's not necessary to have those criminal principles to lower the threshold. And so I think it'll be really interesting for all of us to keep an eye on what the Supreme Court of Canada does.
Yeah, I mean, it kind of opens the door to something that was done in the 90s when the Harris government was in, about kind of challenging the impartiality of the whole tribunal. In this case, it's a different kind of institutional weakness or impediment to access to justice that could result in a challenge to the tribunal as a whole.
Right.
Okay, thank you so much, Wade. You've touched on a lot of important points, and let me move then to Antonella.
Thank you, Raj, and thank you to Brian Cook and Kathy Laird for inviting me to participate today. So as Raj said, I represent respondents in human rights applications, including the Toronto Police Services Board, the Chief of Police of Toronto, and the City of Toronto. So I was asked to speak today from the respondent perspective and to speak about my experience with the system for enforcing rights in Ontario. I won't repeat what Professor Levesque said. She took us through a wonderful overview of the history of human rights in Ontario. And I'll just highlight that 14 years ago, as Professor Levesque said, we changed to a direct access system in Ontario. And the reason that we changed to that system was to address some backlogs that were plaguing the human rights system. The backlog was rendering it sluggish, slow, unresponsive to change. So it was in a crisis of legitimacy. And 3 years after that system was in place, Andrew Pinto, now Justice Pinto, released a report reviewing how the system worked. And I was on a panel with now Justice Pinto talking about his report. And I remember he said, this system's working pretty well. He had some fine tuning to do, as you would with any new system. And he laid that all out. I spoke at the panel too, and as respondent counsel, I said, system's working pretty well. I too had some suggestions for improvement of the system, and I'm always pushing for, I remember my words, a gold standard human rights system in Ontario. Because as Professor Levesque said, we are the leader in human rights in Canada. It's a position that as an Ontarian I'm proud in, that we were the first to have a human rights code, and we continue and want to continue to lead in this area when we're talking about people's rights, their dignities, and these are quasi-constitutional rights. So thinking back to that history and the direct access system, and as I sit here today and I evaluate where we're at, I'm sad to see that our human rights system is once again facing a backlog. It's slow. It's facing what I would say a crisis of legitimacy, or it's starting to face that, which sort of gives rise to discussions like we're having today. So to speak about the effect on respondents and what we've observed, there's a delay, and this follows on the Blanco discussion, a delay between when an applicant files an application with the tribunal and the respondents are served, when the application is delivered on us to respond. So that's not the fault of the applicant. The Human Rights Code has the 1 year, let's say, limitation period in it. And applicants sometimes will file it 1 day before the year is up. So they meet the Human Rights Code. That application, in several cases that I've seen, will be sitting in the tribunal's queue for 3 months, 4 months, 5 months, 6 months before it's delivered to me as a respondent. So then, I need time to reply, and we're already at whatever the period is, plus my 35 days and so on. That's well over the limitation that is permitted in the legislation, and that is institutional delay. So that affects us, and the longer that goes on, we rely on Blanco, we rely on these cases to show that there's institutional delay that is potentially significantly prejudicing us, and we reserve the right to make those arguments. And to be clear, I do not want to be making those arguments. I want to proceed with the case because a proper functioning human rights system is in the interest of applicants and respondents. We want to go in, we want fairness for both sides, and we want to move quickly through the process to either resolve a case at mediation or to go to a merits hearing and get a determination where we can't or we don't think it's appropriate to resolve it. So there's that delay that's out there that's significant, and I want to be clear, it's not when the tribunal is looking at it and thinking about whether they should dismiss it and then writing to the applicant and asking for more information. There have been several where it's a clean case, where it's just sitting in the tribunal queue. That should be easy enough to fix, I think, with proper staffing, proper review of the application coming in and pressing send. They come electronically now. There's no reason it should take that long. Other areas where that happens is the response is filed and then it's delivered to the applicant months later. So I'm not sure why that's happening again, but there's another point of delay there where I file my response and then we're waiting 3, 4, 5, 6, 7 months for that application to be, for that response to be filed to the respondent, who then has a right of reply. And then after that, we sit and wait for mediation. And then after that, if it doesn't resolve, there's a hearing. So that gap, they sound like, oh, it's just 3 months. Oh, it's just, you know, we're backlogged. These are areas that are, I would say, easy fixes if we're looking through a logistics chain and we sort of say, these are areas we can quickly go in and fix: proper staffing, proper training, duty counsel, and so on. Mediation to hearing is another area where that's happening. So if the case is not resolved at mediation, we're told it's going to go to hearing. We're ready to go to hearing if that doesn't happen, but we're waiting a long time, over a year and a half, to even get any acknowledgement that this is at any time going to be set down for hearing. So that's an issue as well. Preliminary decisions, often there's cases where some issues, you know, are proceeding, but then we raised a preliminary issue, let's say, on another point. To get that preliminary hearing, lots of time passes to schedule it. Then we have the hearing, and then we're hearing from decision makers that they want to get to the decision quickly, and I believe they do, but they have so many other things to be doing and writing before because of the case log backlog. So that's a problem. And these are areas, again, where these are not sort of head scratching, how do we fix these delays? It should be moving much more quickly to preserve both applicants' rights to fair hearing and respondents' rights. Decisions. This is another area, apart from these delays at the tribunal. The decisions are taking long to come down, and there's a particular area where there are reconsideration requests that an applicant has made. They're filed with the tribunal, and we're waiting 2 years, 3 years to get that response on the reconsideration request. Now, I'm the respondent, so I'm sitting with an application that has been successful, or a summary hearing decision that's been successful for my clients. The applicant files reconsideration. We can't close the file at this point. We can't proceed. We continue to have a respondent who has an allegation potentially hanging over their heads. So these requests for consideration, again, should be something that in the previous days, like 3 years ago, 4 years ago, 5 years ago, when the direct access system felt like it was chugging along at a healthy pace, we were getting those decisions quickly. And we were moving on from there, and applicant was moving on from there, because an applicant would feel concerned, feeling they have something out there that they think is a decision that's not proper, and they've sought reconsideration. They're still waiting, as are we. The solutions to these seem fixable. And, you know, also, I just want to highlight, when we're looking at, you know, we want a system that's fair for both sides. When we're looking at respondents, again, it's no pleasure for any respondent to receive a human rights application and to have an allegation, you know, that you're racist, that you're sexist hanging over your head. And these are things that respondents take seriously. And the longer this proceeds, the longer it takes for you to tell your side of the story, the longer you know, can get a decision or a resolution at mediation. Causes stress on respondents. Let's not forget that. So we want to push forward. We want to move ahead. We do not want to be bringing blanco and institutional delay motions, but this is something that, in the interest of the client, we have to do in the event that the delay rises to the level that we are prejudiced in responding. And that's going to have to be dealt with. So we don't want that to happen. I'll just close by saying when I heard Wade say 8,000 cases is the backlog, I remember I was chair of the Practice Advisory Committee to the Human Rights Tribunal, and we were getting statistics and advising the tribunal on practice issues. And when we would see the numbers creeping up, oh, it's 200 or it's 100, or we'd immediately look at that. And our interests, all of us, applicant side, respondent side, bar association representatives, had an interest in making sure that we analyzed why that was happening and that we were pushing the tribunal to get ahead of it, right? That we couldn't continue to see those numbers rising because we would be in a position where things are slow and sluggish and aren't moving ahead, so that we're not getting determinations on any cases. I'll leave it at that. I could say more, but I think, I don't want to take too much time. But if Raj, you have any questions, I'm happy to respond to them.
Let me put one of the questions that was in the Q&A to you, and it's about the delay issue, which obviously is a recurring theme here, but in particular, how to challenge the delay in terms of, is it mandamus? Is it the charter? Is it the question actually refers to the Magna Carta to argue the delay, and the question is really whether such a case would be viable in the courts. I guess what we're asking for is, some unprovoked legal advice to 280 of your best friends.
This is something that, we haven't had, I will answer it, but we haven't turned our minds to it because at this point we're reserving the right because we've started to see the concern, very serious concern. It could be cast as an abusive process case. We may put that in front of the tribunal first to be sure we've been sort of gone before the tribunal first, but I don't think there's a lot stopping us from sort of saying abusive process, potentially Section 7 rights being affected, and sort of explaining why those rights are being affected and the psychological harm that that's causing. Blanco, as we said, is being revisited, so we'll see what happens. And keep in mind that in Blanco, it was a 30-month delay, but there were other issues that caused Blanco to feel the stress of what was going on. If you have a purer case where you have delay and you don't have other issues getting in the way of the respondent feeling stress over this or the process not being fair, you could argue, as Blanco has said, that this is delay is something that rises to a certain level, including that it brings the human rights system into disrepute, which is what we're starting to see.
Even then, it was a very high standard that the Supreme Court established, which, even I think he was a former cabinet minister in BC that he didn't rise to that level in terms of psychological harm. I just wanted to touch upon your question, your point, I guess, about, which is, I think, a common experience about applications or responses not being served, I'll call it served, on the other side for a lengthy period. And has that been your kind of universal or experience? Because I've seen that, and I've also seen exactly the opposite. I actually have a case in which there are 18 applications that have been filed by the same lawyer acting for an applicant against a variety of parties within about 2 months. And they appear to be turned around in minutes, so that they all, get out the door very quickly, with the result that many respondents have very large numbers of applications to respond to at the same time. Have you seen that as well?
I've seen the inconsistency, so that I wonder why is this one moving faster than the one that I had filed? My response had gone in earlier, and anecdotally through my colleagues, I hear the same thing, like, why are we still waiting for X, but then this other complaint is moving faster? And so that just makes me think that, I mean, it shouldn't be left to chance. And if you were an applicant and you knew that one was proceeding sooner than yours and yours had gone into the queue sooner, you'd probably want to understand why. So I've been sort of scratching my head and wondering. For me, it's like, well, I'm glad it's moved on, but I have been seeing inconsistency that I can't make any sense of.
Okay, thanks very much. We should move on to Risha. It's almost 12:30, and so I don't want to be eating into your time. I should mention that as others are aware, I'm going to have to step away at 12:45. So, but by all means, that doesn't mean the session has to end. But by all means, go ahead, Risha.
Thank you, Raj. First of all, thank you to Kathy, Laird, to Brian, and the organizers for organizing this discussion today. It's a very important one, and for inviting me to be a part of it. And of course, just my own quick lawyer disclaimer that any comments that I make are obviously very much my own. So the benefit of going last means that a lot of what I would have touched upon has already been in some ways very eloquently put by my fellow co-panelists. Thank you for your comments, along with echoing sort of wholeheartedly what you have said, particularly surrounding delay and solutions for moving forward with the tribunal. I wanted to use my time specifically to speak to the things anecdotally and in my own practicing capacity that I'm currently seeing, coming from my perspective as an applicant side lawyer in the community legal clinic system, representing low income and often marginalized clients in their applications for discrimination at the tribunal. And specifically, I want to speak to and expand upon some of the issues that have been identified by Wade and by Antonella in their comments surrounding delay and the overuse, I would say, perhaps, of notices of intent to dismiss and the impact that that's having on options for access to justice for my clients in seeking remedies for discrimination. So, I mean, at this point, I wasn't around for the 2008 changes to the Human Rights Tribunal, but I had the benefit when I started practicing in the mid-2010s of the system that had been established as a result of those changes. And at this point, I feel that I'm practicing for a completely different tribunal than what was in place a few years ago. And I say that for a couple reasons. One, I mean, much has been said today already about the delay, but I think that's worth emphasizing to underscore the consistency that practitioners, it seems like on both sides, are experiencing in terms of processing and timelines. Prior to a couple of years ago, I mean, like no tribunal or court is ever perfect. Particularly, it can't be given the over 4,000 applications that are filed at the HRT every year. But at least I was able to give clients a fairly accurate timeline of how long various steps would take at the tribunal. A month to maybe 2 or 3 months for the notice of application to be issued. Couple months maybe after that, depending on the circumstances and processing timelines for the response to come through. Mediation date probably within 6 months, maybe sooner, depending on if there was a blitz at the tribunal going on for mediations, and then a hearing date for a merits hearing maybe within a year or so of the mediation if the matter didn't settle. And obviously different practitioners' experiences were different, but this was my pretty consistent experience prior to a couple of years ago. But fast forward to now, and Raj, you had asked Antonella about her experiences reserving notices of application, and I can confirm that I have a number of applications that were filed over 6 months ago, maybe longer, which haven't even been served to the respondent. There's no procedural issues or noise that have been issued, but they're still sitting in the queue. Merits hearings for new matters, to my knowledge, are nowhere in sight. It's good to hear that some of the canceled hearings are now going ahead, but new merits hearings are not happening. And another interesting thing that I noted in my experiences over the last year, in mediations, a lot of the mediations, in fact, nearly all the mediations that I have participated in have started off with a note from the adjudicator running the mediation that the hearing dates are only expected to be scheduled in 2023 or 2024 for mediation that's happening in 2021. So that's concerning. That's also sort of something that's being, I guess, utilized to try and encourage parties to settle, although obviously that's always a good thing, but that's, you know, a bit concerning just from a procedural standpoint, because now it's to the point where I am warning clients before going to the tribunal that by choosing this route, they will have a long wait between each step in the process. And I'm honestly now really not able to even answer their questions about when things are going to happen in their cases, because we simply have no way of knowing, and or things are inconsistent, like Antonella touched upon as well, right? Where I have a couple of other cases where, for example, something was scheduled quite quickly, but then other things are just sitting there, like I mentioned. The other reason I say that I feel like I'm practicing at a completely different tribunal is the adjudicators that are now no longer there. And again, this is not me trying to criticize any specific adjudicator. I know it's a time of transition for the tribunal, but I miss the expertise that we used to see at the tribunal. You have to keep in mind that many of the clients that I represent, racialized, from marginalized communities, from probably life experiences of systemic oppression that comes with living in low-income communities, and of complex discrimination, as well as just coming to the tribunal with the trauma that can come from living through that. So then it's concerning, quite frankly, for then appointments to be made over the last few years to the Human Rights Tribunal, the place that should have the expertise to rule on, understand, and analyze such lived experience against the background of code jurisprudence. It's concerning to have so many decision maker appointments in the last 2 years that have little to no background in administrative or human rights law. Granted, you know, that it sounds like like this can be learned, but it's also just, this is not a tribunal where simple licensing decisions are being made. The people making decisions and, you know, even analyzing issues in mediations, it's imperative for decision makers to be appointed that understand the nuances that come with the issues that come before it. Because ultimately, human rights jurisprudence and human rights code issues are of a quasi-constitutional nature. We're determining and advocating for clients on equality issues, systemic issues, and I don't understand why background experience in human rights in particular, or even in just adjudication experience in particular, is not being prioritized in the appointments that have been made in the past couple of years. Another trend that I wanted to expand on, which Wade mentioned, and I think I'm also seeing, is the use, or perhaps even overuse rather, of the notice of intent to dismiss process. Again, not sure if this is a method to clear up the backlog at the tribunal, or, you know, like Wade said, a learning curve, but I am also seeing tribunal initiated notices of intent to dismiss for files that I've seen, and for, you know, for hearing from colleagues in cases where it just makes no sense. I echo the comments that were mentioned about the overuse of the word jurisdiction, because in the notices of intent to dismiss that are being issued, suddenly jurisdiction is being used to allege that, oh, okay, the tribunal has no jurisdiction over your application because we don't see a connection between the code and your allegations. And I've gotten those kinds of notices of intent to dismiss for cases involving sexual harassment in a workplace, where the connection is quite clear. Jurisdiction is also being used in an increasingly expansive way to hone in on timeliness as a way to dismiss things early in the notice of intent to dismiss process. I mean, suddenly there's the limitation period application of the 1 year limitation period application was always quite strict. It suddenly got even stricter, such that I've heard from and seen notices of intent to dismiss where the tribunal will have an application where the date of the last event was within the 1 year of filing. Somehow that is overlooked, and instead a notice of intent to dismiss is issued for whatever outside of the 1 year limitation period, non-timely allegations were in the application. You have to go ahead and file submissions on that, or the client is forced to respond on that issue. So there is an increasing scrutiny for some reason on timeliness, even more than perhaps there was before. And I mean, we can go to CanLII for the last 6 months and see how this is reflected in the jurisprudence. You're seeing dismissal after dismissal after dismissal. And you're also seeing, I actually had it in my notes to mention the exact same case that Wade mentioned regarding the 3-member panel. It's called Jacobs and My Healthcare, where you just see a 3-member panel sitting down to not just make comments about the jail and Empower Simcoe case in the manner that happened, but also to dismiss a very simple, what sounded like a very simple disability case, and also make findings, it seems like, on the substantiveness of the discrimination allegations at a summary hearing stage. I'm not counsel in that case. I wasn't involved in that case, but I'm just pointing that out as an example of the sudden intense scrutiny that is being applied to applications in a manner that I'm not sure is necessary, and is quite, quite frightening to see sometimes, especially given that I'm now seeing and hearing about maybe even a step further happening, namely that I'm hearing from colleagues about more than one instances where the tribunal will issue a letter, not even a notice of intent to defend, or intent to dismiss, but a letter to an applicant directly prior to the application even being served, and stating in the letter that an adjudicator has reviewed your application and requires you to provide evidence to the tribunal of your discrimination allegations, or else the application will be dismissed. So, I mean, that's not in keeping with the standard practice or procedure that we've seen from the tribunal before. And certainly, evidence has normally either been requested at a hearing stage, summary hearing stage, when the arguably relevant document stage. But I mean, that's just, there is this sudden scrutiny on whether or not applications should even be allowed to proceed. I wonder if that's adding to the backlog and the delay, but this is new and something that is, I think, of particular concern. And I mean, another thing is just that I'm speaking for my clients that I represent, but the tribunal's direct access system was remodeled to be more accessible for all parties, including self-represented litigants. And this is something that I think particularly hits them hard, because you do hear of people not getting these NOIDs until later, or not responding to the NOIDs in time. There's often quite tight timelines attached to these NOIDs. And if they don't respond, their cases are dismissed. And how is a self-represented litigant to know how to frame a jurisdictional question over their simple and clear human rights application, right? So that's also something to keep in mind in terms of the impacts that this is having from an access to justice perspective. So look, I'm not, like, the final point I want to make, I'm not trying to raise all of this by any means to complain. Rather, I'm trying to say all this because I'm seeing it impact the decisions that litigants are making, and the advice that I find myself giving my clients, particularly from the social context that they're situated in. I'm having to explain to someone who's been through sexual harassment and assault in the workplace that their application hasn't been processed, and it's been 6-7 months. And it's because of some of these issues. I hate saying this, but I find it sometimes even more prudent to try and avoid going to the tribunal if litigation is necessary, in the tribunal's current state, just given the ongoing delays that I don't want to have to put through someone who's perhaps already enduring their own trauma, or being through extremely difficult circumstances. If it's an employment law case, for example, and there's a wrongful dismissal that it can be tied to, or civil court process that it can be tied to, perhaps that's the better way to get this person to a speedy resolution that might not currently be available at the Human Rights Tribunal in its current state. And I mean, even for facilitating settlement, a lot of settlements in employment law cases, including human rights, happen prior to litigation starting. But I don't know, and Antonella might be able to comment on this better, but from an applicant side practitioner's perspective, it also just feels sometimes like the litigation threat of going to the tribunal that might facilitate a settlement pre-litigation is almost lost at this point, because if I tell a respondent that, okay, I'm going to go to the tribunal, they can say, okay, well, we'll see you in 3 years, 4 years, right? Again, I'm speaking from the perspective of my clients who are low income, under-resourced, and are going to have to put in a lot of time, emotional energy to have to go through that, compared to, even though it's a stressful process for everyone, but compared to a more well-resourced respondent on the other side. At the end of the day, this is an access to justice issue. There is a lot going on at the tribunal that you've heard about today from my colleagues, from myself. And I just want to end off by pointing out, this tribunal, like I started off with saying, was designed and modified back in 2008 to be directly accessible. And it's unfortunate, just when we were seeing higher damages awards in areas like sexual harassment, really great developments in the jurisprudence, this forum was suddenly brought to a halt. And my fear is that if the procedural and complex issues that we're talking about today aren't addressed soon, we're going to lose the one place that would actually be able to understand with sensitivity and nuance things like systemic discrimination. And that this is the kind of forum that we really need to be functioning right now in today's times, and with these issues ever persistent and ever ongoing, with the inequities that the pandemic continues to bring out. So those are my comments, and I thank you all for having me. Happy to answer any questions before you have to dash off, Raj.
Thanks very much, Risha. Let me ask this, and others may want to chime in as well, because it's a very general question, but it's an important question. And that is, what are one or two things that the tribunal should be doing that it's not doing, that you can see as being a quick fix to some of the broad systemic problems that we've been talking about here? And let me throw out one possibility that was raised in one of the questions, and that is about the virtual first initiative. And where does that where does that stand amongst the potential measures that can or should be taken?
Yeah. So
I obviously invite others as well after you've spoken. And unfortunately, I apologize and thank all of you for wonderful presentations and a lot of excellent ideas, which will, as I say, go into the paper that's being written. And I'll leave it to you.
Thank you. Thank you so much, Raj. It was also just such an honor to be speaking with you here today. So I appreciate that. I mean, one or two sort of as a quick fix, I think I'm going to echo what Antonella said. There's clear the backlogs for the straightforward cases that should just be processed and delivered to the other side, right? Like, we shouldn't be waiting months and months for notices of application or on the respondent side's response. I think thinking about who you're appointing in the future and taking seriously the fact that, again, this is not, a simple licensing, not to denigrate that at all, but there are very, very complex and nuanced issues that come before the tribunal. So it is imperative to appoint people with experience and understanding, or even if they don't have that experience, then the ability to understand that and the demonstrated ability to understand that and adjudicate on those issues. And I mean, in terms of virtual first, there's drawbacks and there's helpful things. I mean, the drawback is obviously that a lot of my clients don't have really great technological access. or language barriers is a big thing with my clients. And another thing that I've seen is just like there was one case that I was working on where the client in particular was hard of hearing, and they needed an in-person mediation in order to accommodate their ability to participate. And I mean, the thing we had to tell them was essentially, okay, well, we don't know when in-person mediations are going to be scheduled. So, I mean, I don't know how much guidance has been released on that amidst the going forward of virtual first, but I think those are things that need to be considered in whether we want to, particularly as the place that makes determinations on accommodation questions. I think that's something that is really, really important to keep in mind. And I think that applies not just for the Human Rights Tribunal, but even like landlord tenants, like that's been an ongoing concern of many other people that have been commenting on the digital first strategy of the tribunals. So, but yeah, I think those would be my thoughts on that.
Thank you very much, Richa. I'm just going to step in quickly because Raj has had to go. But just another question for all the panelists. With respect to the direct access model, has it been, in your view, a failure, or the direct access system, has it been a failure? And this is open to any and all panelists.
So I might go first on this. In my view, the direct access system is the preferred model. I remember under commission models, the delay being excessive. And when the direct access model was functioning at its best, we would be at a hearing within a year and a half, at most. And so, I'm a fan of that model. I think it promotes access to justice. I mean, there's some cons to it as well relative to a commission type system, but I don't think that what we're seeing here is a result of the direct access model.
Yeah, and just my experience practicing before the federal system, I don't think the commission does either role well when it has the dual mandate of screening and doing public interest and education. I think it's very hard for the commission to be effective at both when they're trying to be objective and then they're trying to be pro-human rights. I don't think you can be both. I think it puts the screening function of the commission is just another time suck, and it's people who aren't experienced in human rights and who aren't experienced in adjudicators making those decisions. I've found that the rights-based mediations before the tribunal really, really helpful at getting settlements when the adjudicators were very experienced. They would tell you what the flaws were in your complaints and your chances of success. And I found that very, very helpful as a practitioner. And the federal commission process, I just, the commission is also under-resourced, but they're constantly getting valid complaints dismissed. And there's, 2 opportunities for a complaint to get dismissed before it even gets to hearing. And that's not really helpful for access to justice for respondents or complainants. So I really do not support the filter role of the commission. I don't think it's effective. I don't think it's helpful for complainants or respondents, but I'll just agree with what Wade said. I don't think the problem here is access, the direct model. That's not the problem. It's just not having members and experienced members hearing those hearing applications.
I can add some comments, and that is, for me, the question is bigger than that. It's if we're going to have a proper functioning human rights system, these are rights that are quasi-constitutional right, that goes to people's dignity, to their worth. They're considered high rights at law. We need whatever system it is to be set up, resourced in a way that recognizes the significance of those rights in society. So does that mean more duty counsel being available? Probably to assist people who are unrepresented. Does it mean you have more processing staff? Does it mean you're hiring people to do like a logistics review of the process? You need a system that is properly set up, properly resourced to give these rights the meaning that they deserve in society. So I think that applies to whatever system we're in. And historically, I think we've seen people writing many articles, and if you review way back to 1962 to 1992, I remember studying that at one point. It wasn't a tribunal, it wasn't a system, even under non-direct access, that was funded in the way that a lot of people who were writing and thinking about the issues at that time thought that it should be. And so I see from my perspective a significant need, like happiness when the Human Rights Legal Support Center is on a case, because that assists the applicant, it assists me too in picking up the phone and having a conversation and saying, hey, what should we do before mediation? Or, these issues, I'm not so sure, I may have to bring a motion, and having those discussions with the other side. When there's someone unrepresented, I'm careful because I don't want to be in a position where I could be seen to exert my, authority as counsel over someone who's unrepresented. So we love Human Rights Legal Support Center being there. Are there other places you could have duty counsel? This was something that did come up in Andrew Pinto's report. So that you could support the process. Because in the end, you want a fair process for both sides, whatever you're on. And when we're looking at it and revising it, efficiencies shouldn't be reached sort of, oh, well, we can move it more quickly if we cut this from the process. We need to look at what we're cutting from the process to be sure that any efficiencies achieved are not on the backs of applicants or on the backs of respondents, that it's a very fair process through and through. There's ways to do it. It might not be easy given how far we are along now with the backlog, but is this system worth saving and keeping Ontario in the leadership position in human rights? You bet. I mean, our system and democracy depends on it.
Yeah, I don't have much to add. I just say I'm going to echo everything that's been said. And I mean, I think the original question is this a failure? It's not a failure until it can be fixed, right? And I think there's still a lot of things that we can do. But a direct access system, I think, is what we have in Ontario as a model, and for other provinces. And I think it's something that is important to maintain. It's just there's a lot of fixing that needs to be done, as is evident.
Well, thank you, everyone. So we're going to wrap up the presentation. I would like to thank all the panelists for being here today and for your insightful remarks and answers and presentations. I'd also like to thank Tribunal Watch Ontario, with whom we co-organized the event. You can get more information about them at tribunalwatch.ca. So this concludes this panel presentation. Thank you all for attending. Merci beaucoup à tous et à toutes d'être présents aujourd'hui. Et je vous souhaite une excellente journée. I wish you all a great day. Thank you, everyone, and goodbye.